It is SB 443. Item number 6.
Thank you. Case vote. Thank you very much, Madam Chair. Another meaty issue that I brought to the attention of the committee today, and that deals with civil asset forfeiture, Senate Bill 443. I appreciate the opportunity to discuss this critical public policy issue and our effort to protect California property owners from abuses in civil asset forfeiture and to ensure that law enforcement engaging in civil asset forfeiture are subject to California state law. SB 443 focuses primarily on due process. It's a multi-pronged approach to a problem which has reached epic proportions nationally, but also in many California communities, requiring that in most cases, a defendant be convicted of an underlying crime before cash or property can be permanently seized. Hence, the focus of this bill being primarily due process. It will require that more drug asset forfeiture cases be handled under state law rather than transferred to federal courts in order to ensure the stricter standards under California law are followed. I have been really taken aback by some of the stories and statistics in a report that was issued recently by the Drug Policy Alliance concerning the practice of civil asset forfeiture. The idea that law enforcement can permanently seize a person's assets with no conviction, with the onus on the accused person to prove their own innocence as opposed to the other way around, really is shocking. I'm sure you'll hear from some today that maintain that the loss of the 1% funding to be used for ethics training flies in the face of the bill's ultimate intent. My staff and I have read through a over 220-page manual used for ethics training around asset forfeiture, and almost all restrictions and rules in the manual apply to criminal asset forfeiture.
Wonderful.
So we currently have a case of the proceeds for civil asset forfeiture funding the ethics training for another type of forfeiture. But I concede that should SB 443 pass, training will need to take place to update law enforcement on these new restrictions. I'm open to working out the funding for ethics training in the Appropriations Committee should the bill proceed past this committee. So specifically, SB 443 will do the following. It will address the issue of equitable sharing with the federal government, which results in California cases not adhering to California state law. It increases protections for California property owners by requiring a conviction if the property is to be taken permanently. It gives people who have had property seized the right to an attorney. The right to an attorney is currently guaranteed under criminal law, not so under civil law. It allows for recovery of attorney's fees if the person is found innocent of the crime they were accused of. It also shifts the onus from the person having to prove their innocence to law enforcement to prove guilt, like in every other criminal instance. It increases transparency. Current law requires the Attorney General to issue a yearly report, which SB 443 builds upon to include the number of cases initiated under state law versus those involving the feds, the number of suspects charged with crimes, the disposition of the cases, etc. It adjusts the distribution of seized funds in such a way as to take the incentive off the table for local law enforcement to focus an excessive amount of its energy and resources on asset forfeiture and increases the amount of money allotted to the courts to try these cases. At the height of the drug wars in the 80s and 90s, many state legislatures made seizing assets easier with the goal of stopping the rise of drug use by hurting drug dealers basically where it hurts, by cutting them off from the fruit of their labor and their criminal activity. The result is that we have seen civil asset forfeiture skyrocket with little legal recourse for the person whose possessions are seized. There's been a national bipartisan call for changes to how both the states and the federal government approach asset forfeiture. There was a U.S. Senate Judiciary hearing, I believe, just last week on dealing with this issue at the federal level. Again, 443 reestablishes the most basic tenets of constitutional law and values and ensures that California state law is being adhered to. I think that there's a growing perception that we as policymakers and law enforcement can't afford to allow to continue, and that is that asset forfeiture is used to supplant lost public funding to law enforcement. For civil asset forfeiture to not require a conviction, I think is a crime in and of itself. We have a variety of witnesses here to both testify in support of the bill as well as to answer questions from committee members, and I respectfully ask for your aye vote.
Okay, 2 witnesses in support, 1 minute each.
Just figure out who.
Yeah. Okay.
Good morning, Madam Chair and members of the committee. My name is Jonah Engel, and I'm here to express my support for Senate Bill 443. I'm an investigative reporter and the author of the new report looking at the use of civil asset forfeiture in California. My reporting spanned several years during which I interviewed dozens of law enforcement officials, legislators, forfeiture lawyers, and the targets of seizures. I also filed numerous public records requests at the city, county, state, and federal level. As you know, the abuses associated with civil asset forfeiture were recognized years ago in California, when a series of scandals galvanized support for reform to state forfeiture law. These reforms improved due process and reduced the share of forfeited assets flowing to police coffers. Subsequently, some law enforcement agencies have found a way around these safeguards. They are opting instead to pursue forfeitures federally, where none of the protections contained in state law apply and where police get to keep more of what they seize. Between 2005 and 2013, state forfeiture revenue in California stayed flat. Meanwhile, federal forfeiture revenue flowing to the state more than tripled. This has in large measure rendered null the hard-won protections adopted by California. What I found in the course of my reporting was that some law enforcement agencies have come to depend on civil asset forfeiture revenue. This runs counter to federal and state regulations, which stress that forfeiture is a law enforcement tool and not a way for cities and police departments to generate additional revenue. I found numerous instances in which California law enforcement agencies were budgeting future forfeiture revenue in violation of state and federal regulations. In a number of cities, forfeiture revenues were modest until police department budgets were cut, after which forfeiture revenue spiked. I also found evidence of supplanting, in which a police department's budget is cut by the same amount it made from forfeiture the previous year. Again, a practice forbidden under state and federal guidelines. I also uncovered other ways in which the pursuit of revenue distorted law enforcement priorities. Some of the cities with the highest rates of per capita forfeiture revenue in California have police officer to citizen ratios that are below state and federal averages. Despite this, some of these cities increased the number of officers assigned to asset seizure at the same time as the overall size of the police force was cut to the bone. Finally, the work of law enforcement is difficult and vitally important, and as such, it deserves proper funding. Seizing the private property of Californians who have not been convicted of a crime, as is happening currently under civil asset forfeiture, is no way to achieve this goal. Thank you for your time.
Thank you.
Thank you for letting me testify. My name's Diane Goldstein. As a career police officer, I served over 21 years fighting gangs and narcotics as a member of the Redondo Beach Police Department. Last week, I watched the U.S. Senate Judiciary Committee hearing on the need to reform asset forfeiture. The Fraternal Order of Police stated publicly that the police have come to rely on civil asset forfeiture, the only area of law enforcement where we get fiscal incentives, and unlike criminal asset forfeiture, does not require conviction. It is this statement that is the crux of the matter and is the issue that our legislators must fix in order to prevent the conflict of interest that arises when police have a budgetary stake in forfeited property. I want to be clear. This bill does not stop law enforcement from seizing asset. It only requires us to follow state law. As a sergeant in our Special Investigations Unit, I was tasked with oversight of our forfeiture program. Our city officials and at times my agency lacked understanding of federal guidelines and state laws. This could have resulted in taking property from citizens, sometimes without charge or conviction, to supplant our budget. During budget sessions, city administrators would attempt to plan our budget around seizures, prioritizing this funding stream in an attempt to cut the overall public safety budget and save money. This pressure occurs not just in my department or my former department, but also in other agencies across the state. California, like many other states, have recognized that legitimate public safety objectives can be satisfied through criminal forfeiture. Yet the drug war is used to justify the seizure of assets without being required to charge the owner of a crime. One example is a freeway interdiction of a food truck owner traveling to purchase property who had over $10,000 in hand traveling from Northern to Southern California. He was stopped by a local law enforcement agency who took his $10,000 cash based on simply the sniff of a dog alert. This innocent owner was never charged with a crime and was never convicted of a crime and attempted to obtain his property back through the state remedy. At a local court, a local county judge ordered that his assets be returned, but the local law enforcement agency had already sent his assets over to the federal government, who did not require any type of conviction. I support, as well as Law Enforcement Against Prohibition supports SB 443, as it will greatly reduce these abuses and conflicts of interest within the ranks and will ensure that law enforcement agencies respect and protect the property rights of all innocent residents.
Thank you. Others in support, please just do name and your organization.
And good morning, members of the committee. Teshi United for the Drug Policy Alliance in support of the bill and also here to answer technical questions about the bill.
Thank you.
Madam Chairwoman, Francisco Labaco on behalf of the American Civil Liberties Union. This is one of the more significant reform bills for the year. We urge your support. Thank you.
Thank you. Others in support? If you could make room for them at the table. Would you turn, yeah.
Sorry, Bobby Walker with Public Interest Advocacy on behalf of the California Public Defenders Association in support.
Jim Lindberg on behalf of the Friends Committee on Legislation of California in support.
Jesse Stout, Legal Services for Prisoners with Children, support.
Andrew Kloster, I'm with the Heritage Foundation. We have no position on the bill, but we're happy to talk about the problem of asset forfeiture.
Okay, thank you.
Mark Lenzel, a member of All of Us and None, support the bill.
Thank you. Others in support? Seeing and hearing none, speakers in opposition to the bill?
Thank you, Madam Chair. Members, Marty Varenikar on behalf of the California DA's Association. We remain opposed to this measure because it changes the way distribution of proceeds from forfeiture actions are made. One of the points that I would like to point out is this section, Health and Safety Code, section 11488.4 sub K. Under existing law, if the defendant in the underlying criminal case fails to appear, under current law, a criminal conviction was not necessary before the goods are forfeited. Now, under this particular measure, the individual, there would be no forfeiture allowed unless there were diligent efforts made to find the individual. In many of these instances, the drug and money couriers, they leave the minute they abscond from the system, the minute they're able to bail out or be released from custody. Last but not least, one of our primary missions as an association is to provide training for prosecutors and law enforcement on the ethics and the proper use of forfeiture laws. Funding for those trainings came from Health and Safety Code 489 B2D, which gave us, our association, a 1% distribution of proceeds from the forfeiture actions. This bill would eliminate that distribution, making sure that those law enforcement officials and prosecutors who engage in the process are well-trained and ethically prepared to handle forfeiture cases is a great benefit to the public. We fail to see how getting rid of this funding mechanism for these trainings would be beneficial to anyone involved in forfeiture proceedings. We've discussed our other concerns with the author's office. We have also provided them with a copy of our recently revised forfeiture, asset forfeiture manual as a resource. And for these reasons, we remain opposed. Thank you.
Thank you. Others in opposition? Seeing and hearing none, questions or comments from members of the committee? Senator Stone.
Thank you, Madam Chairman. Marty, thank you for your testimony. I'm one that agrees with the author that they shouldn't be losing funds until it's been adjudicated that they're found guilty. However, you brought up a couple points that I think are worthy of discussion. 1% of the proceeds goes to your association, your members, to train them to basically potentially implement SB 443. So I'm going to, in a few seconds here, I'm going to ask the author if she wouldn't mind amending her bill to make sure that 1% of what is collected is still going to continue to flow to you for that educational purposes. And then two, you mentioned the flight of people that are arrested that post bail and take off and you ever see them again. We're still in possession of their $100,000. They're gone because they know they're going to potentially get prosecuted. If there's an amendment that basically says that if there is a sequestration of cash that is gotten through an arrest, and if the alleged criminal does not show up to court to face those charges, that would trigger a forfeiture. If those two amendments would be considered by the author, would the DAs support the bill as it's written?
There are a couple of other concerns that we have with respect to the potential conflicts between the state and federal provisions. I noticed that the analysis correctly points out that California currently has many, many provisions that differ from federal law that provide for a lot of safeguards. I know that the federal government has taken, or at least the federal DOJ has issued new guidelines for equitable sharing. There's some concern that we have with respect to if under equitable sharing, the feds can basically release 80% back, and now you have a 60% distribution cap with the state level, how that's going to work. And those are items that we're willing to continue to discuss with the author's office. Some of those protections we certainly agree with that she's indicated in her bill, and we'll continue to work with them.
Well, I appreciate it. I think the author is certainly on the right track here. Again, I don't believe anybody that is, has a suitcase of cash in the backseat of their car and they're going to go buy a sports car and, may have marijuana sitting in the right-hand seat of the car, and next thing you know, they got their cash that's been confiscated and distributed, and they get found innocent, and next thing you know, the cash is gone. So I don't know how this works, Madam Chair, but I'll make a formal request. I'd be happy to move this item if the author would consider the two amendments that I suggested. One, that 1% of what is collected still continues to go to the DAs for educating the district attorney, investigators and district attorneys on asset forfeiture policies, including SB 443, and if a perpetrator misses their court appearance, skips out on bail, money is held basically in an escrow, and if they don't show up to court and they're unable to be found, that money does get forfeited.
Senator Mitchell?
May I respond? Thank you.
Yeah.
Senator Stone, thank you for trying to work it out. I appreciate it. Let me say, as I said in my statement, yes, they did provide their 200-page manual, and we did review it. It is very clear to me by looking at the manual that the ethics training around asset forfeiture that's currently included in their training, almost all restrictions and rules in the manual apply to criminal asset forfeiture. And so we are taking 1% of civil asset forfeiture to pay for criminal asset forfeiture. So if I were the gentleman in the truck with the $10,000 that was taken out, I know that that's appropriate since I was convicted of no criminal activity. Why are we robbing from Peter to pay Paul? Literally. I am more than willing, as we go to the Appropriations Committee, to continue to talk about it. But as I said, the notion that it is okay to abscond away with the property and cash of private citizens under civil law who have not been convicted of a crime in order to pay for public employee training, I don't think is appropriate. We can continue to have the conversation as we go through appropriations. I'm not prepared to take that amendment today. The other amendment you offered, sir, I would need time to consult with our bill sponsors. We don't have it in mock-up form. I don't know if it's fair to committee members. This is our first stop along a very long process. We will be happy to continue to work with the opposition and consider that, but I can't make that commitment to you today. I don't know that it's fair to the sponsors or the integrity of the bill that's before us today.
Thanks for your consideration.
Okay, Senator Anderson?
I love 99% of your bill, and I plan to vote on it, plan to vote for it, but I think that the concerns that my colleague from Temecula brought up are valid concerns, and I know that you have time as you move through the committees to address those issues. So once I see how those are addressed,
Sure.
I'd like to vote for this. I think that the concerns are grave, and I agree with those. But I do have some reservations on the allocation of the forfeiture revenues. I'm always uncomfortable with the idea of incentivizing people to go after everyday citizens. So that makes me very nervous. And so how you address that will make a big difference in my future votes. So thank you.
Thank you. The bill's been moved by Senator Leno. The motion is due pass to appropriations.
If I could just real briefly, in my
Okay.
motion, just to say that this bill really does defend the basic concepts, as you have said, Senator, of liberty and justice and personal property, and addresses the perverse incentive to seize property from people who have merely been arrested. I think it's a very important bill, and I would like to be joined as your principal co-author.
Thank you.
Thank you. And I move the bill.
Thank you. The bill has been moved. I agree with Senator Leno's comments. Would you like to close?
Very briefly, Madam Chair, and I appreciate your patience with me with these two bills today. You know, as a state legislature, we have considered these critical issues and taken a pretty strong stand in establishing state law. Equitable sharing, walks in the face of state law that this body has deliberated and passed over time. It does create a perverse incentive to violate due process of residents of the state of California, contrary to actions we've taken to protect them. And so the goal of this bill, I think the goal of Attorney General Eric Holder, as he's recently limited seized asset sharing process, although this doesn't go far enough, it doesn't go as far as our current state law, recognizing that assets seized under our state law have stayed flat over years. Assets seized under this asset sharing, where we partner with federal investigative entities, has skyrocketed. You heard the report about municipalities whose civil asset forfeiture earnings, using that term loosely, have quadrupled, are 4 times that of municipalities with 5 times the population. It does not follow logic. It doesn't follow the intent of California state law. That's what we are elected to uphold. And so with that, I hope that you would support this effort to protect the private property of law-abiding California residents. I ask for your aye vote.
Thank you. Please read the roll.
Hancock?
Aye.
Hancock, aye. Anderson?
No at this time.
Anderson, no. Leno?
Aye.
Leno, aye. Liu? McGuire? Mawning?
Aye.
Mawning, aye. Stone?
No at this time.
Stone, no.
Okay, we'll hold the roll open for the absent members. That bill is on call.
Thank you, ma'am.
I believe that Senator Lara is here. Thank you. Item number 10, SB 504. Welcome to the committee, Senator.
Thank you. Thank you, Madam Chair and members. SB 504, the Starting Over Strong initiative, offers us a chance to improve economic opportunities for youth by removing the juvenile expungement fee. In California, we have youth who have served their time for minor misdemeanors and are now ready to turn their lives around and make an honest living. Unfortunately, many of these youth face barriers to employment and housing as a result of their juvenile records. There is a system in place that allows juveniles to seal their records so that their mistakes as youth do not hinder their future opportunities to succeed. This system, however, comes at a price tag. Adjudicated youth must pay $150 to petition the court to seal his or her records. This fee is an impediment for youth who may be eligible for expungement. Filing the petition payment does not guarantee expungement. Furthermore, the fee charged for each attempt is non-refundable. As the law is now, many youth eligible for expungement are discouraged by the cost of sealing. SB 504 seeks to remedy this problem by removing the fee for youth under the age of 26. The law will improve our youth's chances of gaining employment and securing housing. Members, let's give our youth the opportunity to succeed, to become responsible, law-abiding citizens. It is in the best interest for all to give our youth a second chance. This bill will increase young people's ability to turn their lives around, which is the ultimate goal of our correction and rehabilitation system. I respectfully ask for your aye vote.
Thank you. Now we have 2 witnesses in support, 1 minute each.
Okay. Good morning. Thank you for the opportunity to speak before you today. My name is Davon Williams. I'm a member of the Youth Justice Coalition. I come from the grassroots of the struggle. At the age of 2, I was removed from my family because of my parents, who were addicts, were arrested and charged with child neglect. I was turned over into the child welfare system and never returned to my family. By the age of 12, I was stuck in the daily drive, doing anything I had to do just to get by. I was constantly moved through foster homes, and there were many days I didn't know what I was going to eat. There were moments of such deep depression that by the age of 15, I ignored my hunger and optioned for gin. My first arrest was for theft. I was put on juvenile probation for a year. Every month I reported to my probation office. I was constantly threatened that I would be violated if I couldn't pay my fees. 1/3 of youth in LA County probation camps are there for technical violations, whether it's if they couldn't pay fines, they missed appointments, or they missed drug tests. I know it's my responsibility to care for myself, but I was never given any resources as far as education, employment, or housing. All I remember them saying is that I had to figure it out. Eventually, I was living from couch to couch or even on the street sometimes. I applied for every job I could find that had an opening, being to McDonald's, Burger King, Starbucks, from every mall from South Central to the Antelope Valley. But I was denied because of my record. When the door closed, when things felt most desperate, I looked to the streets once again for opportunities, and eventually arrested for burglary and sentenced to a year in LA County Jail with a strike and a felony. When I came home, I was placed on 3 years probation, which extended to 5 years because I could not pay any restitution fees. Today, I'm here to ask you to pass Senate Bill 504. This bill is an essential step towards breaking the cycle and ensuring that youth are not labeled as delinquents. Many of us are trapped because we cannot afford to clear our records. SB 504 offers the reentry population a fresh start, and we need your support. Please help us make this first step. Thank you for your time, and on behalf of all youth of California, please support Senate Bill 504.
Thank you. Next witness.
Good morning, Senators. I'm Jesse Stout with Legal Services for Prisoners with Children. LSPC is proud to co-sponsor SB 504 with the East Bay Community Law Center and the California Public Defenders Association and the Youth Justice Coalition. The current process for sealing California's juvenile records is unnecessarily burdensome for our youth. In Alameda County, youth must pay a $150 non-refundable upfront fee to file a sealing petition. After receiving payment, probation conducts an investigation to determine eligibility. Next, probation recommends to the court, and the court renders a decision in an adversarial hearing where the youth have no right to representation. As you can imagine, this process encourages youth to pay $150 for a remedy they're often ineligible, while simultaneously encouraging those who are eligible but cannot afford $150 to not to apply for sealing at all. There's 14 California counties, including LA, that charge no fee for record sealing, but until 2010, even Alameda County did not charge a fee, When the fee was implemented, the number of young people seeking the remedy dropped by over a quarter. In 2012, Alameda County made $27,000 off this fee, which is less than 1% of the probation department's budget. A coalition of youth leaders have worked to institute a fee waiver process in Alameda County, but the county still does not give notice of the waiver to youth petitioning for record sealing. SB 504 will eliminate the fee altogether and the confusion surrounding it for our youth. As you've heard from testimony today, juvenile records create barriers to employment, higher education, and housing. Without access to key resources, youth are more likely to recidivate and become involved in the adult system. By eliminating the sealing fee, SB 504 will increase access to juvenile record sealing, reduce recidivism, and increase public safety. Thank you.
Thank you. Others, Me Too's, please.
Natasha Minsker, ACLU of California, in support.
Jim Lindberg on behalf of the Friends Committee on Legislation of California in support.
Ignacio Hernandez on behalf of CACJ in support.
Thank you. Are there others in support? Please come forward and just say your name and your position on the bill.
Kim McGill from the Youth Justice Coalition. We're proud to be co-sponsors on this bill and support.
Tanisha from Youth Justice Coalition, support of this bill. I think people need to know that they're going to need to get sealed because a lot of youth think that everything's going to disappear when they're 18. And luckily, I'm in LA County, but there's a lot of young people that aren't aware of this.
Thank you.
Jose Gallegos from the Youth Justice Coalition, and I strongly support this bill.
Danisha Thomas with the Youth Justice Coalition. I strongly support this bill. No one should have to pay to seal their record.
My name is Isis Elena Campos from Youth Justice Coalition. Please support SB 504 so we can have full access to jobs, housing,
Thank you.
and our
Thank you. We have many bills to hear, and many people in line. So,
My name is Emilia Martinez from California Youth Justice Coalition, and I support this bill.
thank you.
My name is Brandy Brown from the Youth Justice Coalition, and I strongly support this bill.
Maritza Galvez with the Youth Justice Coalition. $150 equals a month worth of food.
Thank you.
Jonathan Malagon with Policy Link and the Alliance for Boys and Men of Color in strong support of this bill.
Adela Barajas with Life After Uncivil Ruthless Acts in support of.
Good morning, everybody. My name is Elias Garcia, and I support.
My name is Noe Salazar with the Youth Justice Coalition. I strongly support SB 504.
Good morning, Frankie Guzman, National Center for Youth Law and California Alliance for Youth and Community Justice. We're in support.
Laura Rudolphi for the W. Haywood Burns Institute in strong support.
Lidia Cardona with Laura in strong support of SB 504.
Joanna Sandoval with Life After Uncivil Ruthless Acts, and I support.
My name is Wendy Brock with Youth Justice Coalition, and I support.
My name is Nigel Martinez from Youth Justice Coalition, and I support.
Marcus Higgins, Youth Justice Coalition, I support.
Helen Roth Dowden, California Coalition for Youth.
David Bouchot on behalf of All of Us or None, and we're thrilled to support this.
Hi, my name is Alani Bonilla. I'm a teacher with the Youth Justice Coalition, and I support AB 504.
Rosita Castelar with Youth Justice Coalition, I support.
Sue Burrell on behalf of the Youth Law Center in strong support.
Lizzie Buchan with the Center on Juvenile and Criminal Justice in support.
Anna Cho Fenley, Anti-Recidivism Coalition in support.
Darlene Frontudo, Anti-Recidivism Coalition, and I support.
Gary Scott, Anti-Recidivism Coalition, and I support.
Blake Williams, Anti-Recidivism Coalition, and I support.
Ronald Coleman on behalf of the California Immigrant Policy Center, also here in support. Thank you.
Thank you. Are there others in support? Are there speakers in opposition? Oh. Okay, one more, please.
Sorry. Madam Chair, members, Khalif Basagai on behalf of the California Public Defenders Association. We are co-sponsors and in strong support.
Thank you. Are there speakers in opposition to the bill? Seeing and hearing none, is Senator Leno.
Madam Chair, as I move the bill, I'd like to be added as a co-author as possible.
Absolutely.
Thank you.
Okay, the bill has been moved. Please call the roll.
Hancock.
Aye. That bill is on call. We'll hold the roll open for the absent members.
Thank you, Madam Chair, members.
Senator Nielsen, I believe that you have two bills.